Okay, welcome to our second class on patent law, in which we're going to continue our discussion of utility patents. Specifically, we're going to look at the claims of a utility patent. Now, as I mentioned in our previous class, the claims are arguably the most important part of a modern patent document because they specify the actual property claim that the patent is granting to the patent owners. In other words, they define the scope of the property interest that the patent owner actually gets. And so they determine what it is you have to do in order to be infringing the patent. Now, in the case Markman v. Westview Instruments, the Supreme Court looked at the question of patent law and patent claims and came to the conclusion that the meaning of a patent claim is in fact a question of law, therefore not a question that should go to the jury, and essentially established a situation where federal courts hearing claims, hearing patent claims, would establish or would hold a pretrial hearing known as a Markman hearing in order to determine what the scope of the patent claims actually is, in order to determine what the patent claims actually mean and what they actually cover. And as a practical matter, most patent litigation ends with a Markman hearing, right? The uncertainty from the perspective of the parties is what the patent actually covers, and as a consequence, whether or not the defendant's activities actually fall within the scope of patent protection. So once the courts have determined what the patent covers, the parties have a pretty good idea of how the litigation is ultimately going to play out and are in a position to settle. So, or dismiss the claim, or if it looks like the patent claim has been interpreted in such a way that it's clearly not going to cover, or clearly will cover, the activities or the actions of the defendant. So the Markman hearings really matter, and a lot of time and energy is invested in them. But there was an open question, right, in these Markman hearings, which was, is the entire interpretation of the meaning of the patent claim a question of law, or are there questions of fact embedded within it? And this question came to the Supreme Court in the Tiva Pharmaceuticals v. Sandoz case. What happened there? Well, Tiva is the patent owner, and they're claiming a patent over the method of producing a particular drug used for the treatment of muscular dystrophy. And the key language in question is claim language stating that the active ingredient of the pharmaceutical in question would have a molecular weight of 5 to 9 kilodaltons. And the response from the defendant was that claim is insufficiently precise, right? It's not clear what that claim means. And as a consequence of that claim being unclear, or that element of the claim being unclear, the patent claim itself is invalid. And they observe that there are multiple different ways of defining molecular weight, depending on what you're intending to measure and how you're intending to express the claim. The district court looked to expert testimony as to how a physita, or person having ordinary skill in the art, the sort of relevant reasonable person for the purpose of patent law, how a physita would interpret the claim language, a molecular weight of 5 to 9 kilodaltons. And based on that evidence and that testimony from experts, determined that the claim was valid and could go forward. The Federal Circuit reversed, right? Essentially saying the whole question is a question of law and a question to be determined de novo. And we think that reviewed de novo, this claim language is impermissibly imprecise, and therefore the claim can't go forward. And the Supreme Court said, yes, the claim language has to be interpreted de novo, but to the extent that the understanding of that language incorporates expert testimony and other forms of evidence, the district court's determinations with relation to the evidence and what it says about the meanings of the terms is interpreted or should be reviewed for a clear error, not reviewed de novo. In other words, you look differently at the evidence about the meaning of the terms as opposed to the ultimate conclusion about the meaning of the claim as a whole. Okay, well, how does that play out in practice? Here we have the Federal Circuit in the Tshot v. Green Mountain case, looking at a claim relating to a patent on a tea extraction system designed for the production of tea extract in a coffee brewing device. And it lays out in the claim specifically the elements that it's claiming, which include the element that the device consists of a sealed body constructed of a water permeable material. And in effect, Tshot is bringing this claim against a company that's making Keurig cups or K-cups, right? So you've all seen those before. It's a little plastic cup with a foil lid, and the machine punches through the lid, inserts water, and then the water drips out the bottom. And the question is whether or not the design of the K-cup infringes on the Tshot patent. And Tshot, or rather the problem with the claim is this term water permeable material. And Tshot says, well, the foil lid of the K-cup is a water permeable material because look, it gets punctured and the water goes through it. And the court says, no, that's not the meaning of water permeable material. Water permeable material means a material that water can always go through. In the K-cup, the water isn't going through the material, it's going through a hole in the material. And that doesn't count for the meaning of water permeable material as used in the patent claim. Therefore, the patent claim as written doesn't doesn't cover the invention in question, and therefore you can't proceed with the action. So it ends with the Markman hearing because it's quite clear that after the court's interpretation of the meaning of the claim that the defendant has not infringed. Okay, well, so this reflects the need for claim definiteness. Why do we care about claim definiteness? Why is it important that a patent claim specifically points out exactly what it is that a patent is claiming? Well, because it defines the property rights, and we want potential defendants to know ex ante whether or not they're potentially going to be liable for patent infringement. So the entire idea behind claim definiteness is to make sure that the patent claim as written communicates to the world what it is the patent actually covers, what it is the patent is actually claiming, and therefore what you can and can't do without infringing the patent. Now, it's nevertheless the case that the definiteness of the patent leaves some room for elbow movement, right? Because you can use certain kinds of words that don't claim totally precisely exactly what it is the patent covers, but claim a range of different possibilities. The question is, how wide can that range be? And this came up in the Nautilus v. Biosig Instruments case, which involved a method of effectively filtering out extraneous signals and only measuring a person exercising heartbeat as opposed to those extraneous signals that aren't their heartbeat. And it used multiple sensors that were in a particular relationship with each other. And the patent claims tried to lay out the relationship between the various sensors that the system would use in such a way as to allow for variation with respect to different devices and different applications and different materials being used. And therefore, it stated that the electrodes in question had to be in a spaced relationship with each other. And the question was whether in a spaced relationship with each other was sufficiently definite to be a valid patent claim. And the Federal Circuit standard at the time was that it distinguished between patent claims that were amenable to construction, right? In other words, if you can construct the patent claim in such a way as to make sense of it, then it's valid, as opposed to insolubly ambiguous patent claims. In other words, if there's no way to determine exactly what it is that's being claimed, then it's invalid. And of course, you would once again look to a fausita, right? So a person having skill in the art, would they be able to read the patent and patent claim and determine from the patent and the patent claims what it is that was being claimed sufficiently clearly and definitely that the patent claim would be valid. And the Supreme Court heard the case and said, actually, Federal Circuit, this standard is too broad, right? Or rather, you're giving too much scope of patent protection to patent owners. Insolubly ambiguous is too lax a standard of definiteness, and you should be looking for a more definite statement of the patent claim than merely one step above insolubly ambiguous. Question here, looking at the Supreme Court opinion, what exactly is the standard then that the Supreme Court wants the Federal Circuit to be applying? In other words, how much definiteness is necessary, and how are courts expected to go about determining whether or not a patent claim is sufficiently definite after Nautilus v. Biosig? Okay. So in addition to using information from fausitas and other experts in order to determine the meaning of a patent claim, the patent claim meaning is also determined by the specification of the patent. In other words, the description of the invention can and must inform the meaning of the patent claims. So in the Pacing-Tex v. Garmin case, Pacing-Tex owns a patent over a repetitive motion pacing system that incorporates, among other things, a playback device. And essentially what happened here is that Garmin has a device that tells the user of the device what their current pace is. And Pacing-Tex says, well, that's a playback device. It's a repetitive motion system pacing. It's a repetitive motion system pacing system that has a playback device in the form of a device that tells you what your pace currently is. And the question is whether the Garmin device is going to read on to the Pacing-Tex patent, and that really depends on whether the term playback device incorporates anything in addition to there simply being a display of what the user's pace is. In particular, whether it involves any kind of playback of a perceptible tempo to the user. And looking at the specification of the patent, the Federal Circuit says, look, it's clear that by playback device in this patent claim, what the patent is disclosing is a method of playing something back to the user, playing a tempo, either an audible or visual tempo, back to the user such that the user can match their pacing to the tempo in question. And simply telling the user what their pace is not sufficient to read on to the patent claim in question.